Is it noon? We're ready to go? All right. Just to stay on schedule here, we have quite a sizable virtual event going simulcast. Can you hear me? All right. In and out. Okay. Welcome, everybody. My name is Guy Lehman. I'm an owner and advisor here at Compass Financial, and talking about something that's dear to a lot of our hearts is estate planning. There's a lot to cover. I want to be respectful of everybody's time. We have an hour here today, and I'm going to try to take about the first 35 minutes up with our presentation and leave plenty of time for discussion, question and answers. Compass team in the back, Kurt Pearson, Michelle Bjorkren, Nancy Economist, Caleb Pearson is running the technology here. Thank you, Caleb. Steve Con, Julie Greer, Justin. All right, can you hear me? Am I cutting in and out a little bit? Okay. All right, so also have a special guest, Jana Weiler. Here, she is an attorney for the Davis Brown firm. Her and I go back personally a long time, and then professionally, we've had her in advising several of our clients on this estate planning process. So I'm going to be flipping over to her now and again to fill in some gaps. And also, she's going to be a major part of our question and answer session. So thanks for coming, Jana. So nationally, only about 35% of Americans have an estate plan. I should rephrase that. Actually, 100% of Americans have an estate plan, but only 35% of Americans have a will, which means they've expressed their wishes on how they want their property to be distributed upon death or incapacity. For those that don't have a will in place, the state of Iowa has one for you. They have created a set of laws that govern how your property passes if you pass away without a will. And we'll talk about that. As a disclaimer, we are not attorneys at Compass Financial. We will not be giving any legal advice today. That is a very personal matter that you should be discussing with your attorney, but we will be educating on various aspects of estate planning, legal documents, what they are, what they're used for, and we're going to get to the main question, kind of the headliner of the day, is will versus trust. That's on the tip of everybody's mind, so we'll get into that really towards the end. There's a couple of sayings that we have. Is number one, remember, an ounce of prevention is worth a pound of cure. We say an ounce of estate planning is worth about $10,000. A little bit up front saves a lot on the end. A lot of heartache, a lot of headache, clarity, and confusion. Okay, so here's what we're going to cover today. What is estate planning? What is a will? What is a trust? What is the power of an attorney? What is a living will or health care directive? What assets pass outside of a will? Those are called beneficiary designated assets. What is probate? And we're just going to touch on taxes just a little bit. Okay, so what is estate planning? Next one. It's really mapping out how you want your personal and financial affairs to be handled in the event that you pass away or can't make decisions anymore. Go to the next one. It really allows you to control via legal documents what happens to your property when you die. You know, another saying that we have here is a piece of paper changes the world. And that's really the case when it comes to estate planning, because most of your estate planning takes the form of legal documents. And we'll get into each of those. All right. An estate plan should address how your assets get transferred, as well as the management of your legal or medical care if you can't make decisions. And we'll get into that too. That's power of attorney right there. Now, there's some special circumstances that estate planning can really help manage well. Number one is disabilities, either a physical or mental disability at your level, or the level underneath you that you're handing off to. Okay. Addictions. If you happen to have a child that has addictions that wrapped up deeply with money, right? Drugs or gambling or something like that, you can protect that person from themselves, from giving them a bunch of money, right? Dave Ramsey, who's a kind of financial radio personality, says, if I have a son that's messed up in drugs, giving him a bunch of money is just like buying drugs for him. And I refuse to do that. So these are really special circumstances that you can get into and you can deal with estate planning. Spendthrifts, people that can't keep a nickel in their pocket. Okay, you can deal with that sort of special circumstance through estate planning. Also, unique assets. Farmland is a very common one here in Iowa. How do you deal with farmland when you have the parent and you have 4, 5, 6 kids, some of which farm, some of which don't, right? Very special circumstances that you can use advanced estate planning, sometimes trusts, sometimes wills, to really manage that well. And of course, there's some tax considerations in there too. So who needs an estate plan? Is there anyone who should not have an estate plan? The answer is really no. Well, I should rephrase that. If you're okay with what the state says, and we'll get into what the state says, if you pass away without a will, if you're okay with that, then I guess you don't need a will. But there's a lot of other circumstances here that enter into the situation that I think would be very beneficial for you to at least express your wishes in the form of a trust or a will. Reasons why people don't get estate planning done. Hey, I haven't gotten around to it. Does that sound familiar? Oh, I don't want to think about it. Does that sound familiar? Some people think, well, I don't have enough assets. Well, it may not be about the assets. It may be about protecting or helping somebody in the next generation in a special circumstance. Or I don't need one, right? That's the second one. Okay, next one, legal documents. So we've talked about this. Here's what we're going to talk. We're going to talk about wills as a legal document. We're going to talk about trusts. We're going to talk about power of attorney, both general power of attorney and healthcare power of attorney. We're going to talk about a living will, which is actually different than your last will and testament. Because oftentimes we ask people, hey, do you have a will in place? And they say, well, yeah, I got a living will. Okay, different things, and we'll talk about that. Also, we're going to talk about beneficiary designations. So of all these legal documents, you can pick and choose what works for you in crafting how you want your assets to be handled upon your death. All right. So what is the last will and testament? Simply, it's a legal document, directs how your property will be dispersed upon your death. There's a couple things that happens in your will. Number one, you get to name an executor. And just like the name executor says, that's someone who is going to execute your wishes that you outline in your will. And they do so under the supervision of the court. And that process is called probate. Okay, we'll keep coming back to those ideas. So the first thing you do is get to name an executor. The second thing you can do, especially, here's why a will is especially important for people with minor children, is you get to name a guardian in case you and your spouse are no longer around. So who's going to take care of your kids if both of you pass away? Okay, that's really important to name that person. You want that control, not giving that control to a court somewhere down the road. Okay. What makes a will valid? A will must be in writing and signed. In fact, it must be signed by 2 people. Is that right, Jana?
Technically 3. So you have to sign it yourself, and you have to have 2 witnesses. So
Okay.
there's going to end up being 3 people in the room, you and 2 witnesses.
What else does the state of Iowa say about a valid will?
It has to be in writing. So whether that is typed on the computer, whether that's in your handwriting, that's fine. There's no such thing as a verbal will. So if somebody told me that this is what they wanted to do with their property, unless it's in writing and it's witnessed, that's not a will.
And again, little notes in the file cabinet about who I want to have what piece of property? Not okay.
Yeah, for the most part, not okay. So a little list that said, well, I wanted this to go to so-and-so. Nope, it needs to be in a will. And you need to have those two witnesses.
All right.
Typically, we might do an extra step and have a notary there as well. That makes it easier to admit it to court, but that's not technically required. The two witnesses is what's required.
One additional thing that I found out personally is that you must admit the original wet signed will to the court. They will not accept a copy. Is that right?
Correct. I think a will is the one document left in the world that we need that original. You can send me a copy, but the original that has a wet signature on it is what has to be admitted to the court. The reason for that is if we can't find the original, historically, the assumption was that you might have torn that up, that you might have got mad one day and said, I don't want this will anymore. And how do you destroy a will? You tear it up. So we have to find the original. So we will always ask, do you have the original? Is it in a safe deposit box? Is your attorney keeping the original? That's why we're always looking for the original. And you would want your executor to also know where the original is, because it's great if you know where it is. But if you're deceased, whoever you've named as the executor, spouse, kids, whoever, they need to know where that original is.
On that note, we have printed out several of these personal organizers. Okay, great source of information to give to your executor, along with the location of your original will. And if you don't know where your original will is, it's time to raid your records and start looking for it. Thanks, Jana. Okay, next one. Okay, so determining whether a will is right for you. The advantages are avoids property going to people you don't want them to go to, avoids some disputes over intended beneficiaries, can have some tax advantages, and it clarifies the rights and duties of your personal representative, your executor. Now, there's some disadvantages, and I'd like Jana's viewpoint on this. There's probate fees. So probate, remember, is the process of settling an estate under supervision of the court. So there are court fees, probate fees that go along with that. There's also legal fees, because often you have an attorney helping you through the process. It's not necessarily an easy thing to do on your own. And then there's time delays. Typically, even a small estate can take 6 months to settle. And complex estates can take sometimes several years to settle. So can you talk to us a little bit about the probate fees? I know that's a big topic of discussion.
Sure. And I'll give the caveat of all of these items are going to vary state to state. So the internet is great and the internet can also be terrible. And so if you're looking at things on the internet, it's very important to look at what state are you looking at. So some states probate is just awful, takes forever, really expensive. Iowa is on the side of it's not that bad. There are court costs. We actually just passed a new law, I think effective last January, changing how those court costs are calculated. So essentially we can exclude certain things that we didn't used to be able to exclude. The rough calculation is it's 0.2%, so 0.002 of the assets going through probate. That new law, the exclusion is things that don't go through probate. So things that have a beneficiary designation or are jointly held, we get to exclude those now from calculating the court costs. But yes, there is the time delay, and it, at a minimum, I'd say 6 months is probably how long it's going to take. A trust administration, which I know you're getting to next, might take the same amount of time. So it's really hard to say a generalization of how long something's going to take and whether one's faster than the other. But I think the important part of what Guy's presenting today is you need to look at your individual circumstances and figure out what works for you and what ways you can plan to minimize this. Does it make sense for you to go through probate and have a will? Maybe it does. Does it make sense for you to use beneficiary designations and avoid the whole process? Maybe. Does it make sense for you to have a trust and do this kind of informally? That's also a possibility.
Good. Next. Okay, what is a trust? And again, this topic goes a mile deep in every little area, and we're just going to touch on the top of it. A trust is an arrangement that allows a third party or a trustee to hold and manage assets for the benefit of the beneficiaries. And in other words, it's really a legal entity that can be set up during your life, which is generally a living trust, or at your death, which is called a testamentary trust. The whole point about trust is it can create a level of control far beyond your life, because you can write just about any rule that you want to into a trust. So the whole idea here is control. Go ahead, next. So there are several roles involved in the trust, right? A grantor is the person who creates the trust, who names who the beneficiaries of the trust are going to be, and who puts property in the trust. The trustee is person who administers all the property in the trust for the benefit of the beneficiaries. Now, sometimes the grantor and the trustee are the same, not always. And also at the end, there's the beneficiaries, which actually have no say in all this. They're simply there to receive the property from the trust based on the rules set up when it was created. Okay. So let me give you an example of a testamentary trust, or a trust that is created through a will. So if I have a will, I have 4 minor children under the age of 18. And if something should happen to my wife and I, in my will, there's a provision that says there's a trust created to hold all of our assets and to be managed by a trustee, a third party, for the benefit of our 4 children. That's how that works if my wife and I are no longer alive. Okay, so that's a trust that comes forth from a will. There's also living trusts, and we'll get into that in just a little bit. Okay, keep going. Is a trust right for you? Here's some big questions, because there's advantages and disadvantages. Advantages are typically you can gain access to the assets more quickly after death. In a trust, the trust can control how and when distributions are made. It can protect assets from creditors, divorces, spendthrifts. Remember, someone that can't keep a nickel in their pocket. You can exert more control over that. And a living trust does avoid the probate process. Or what I should say is, property in a living trust avoids the probate process. Now, there's some disadvantages. Changing trustees can be difficult, right? Who is in charge of your trust? And you want to pick that trustee very, very carefully. Fees to set up a trust. Do you pay now? The fees to set up a trust are typically higher than setting up a will. But of course, will has other fees down the road that trusts do not. So it's a real comparison game. The last two is what we see that commonly trip people up with living trusts, is ongoing trust administration and failure to really set it up properly to begin with. So that there's kind of a bar there, an administration bar, that you need to be able to clear to get it set up properly and to administer it properly over time, or your trust doesn't work the way it's intended to work. And sometimes it can blow up in your face. Do you have any input on this?
Yeah. So when the question, what's right for me, a will or a trust, this is one of the pieces that plays into it. You can have the prettiest trust document drafted, but if you don't title your assets into it like you're supposed to, then we still have to go through the whole will and probate process. And so that's the hard part, because the attorneys can't do that for you. And so that's what plays into this. If I have a client coming in that needs to make some sort of update, and then they're asking me, do I want to do this revocable trust? What's their ability and likelihood that they're going to be able to follow through with multiple steps? If we know that they're not capable of doing that, then we're probably just going to stick with the will, because why go to the effort of a trust if they're not going to appropriately do it? A will's not all bad. They both have their purpose, but those are some of the factors. And the one thing I wanted to point out, the ongoing trust administration and expense, that primarily relates to what Guy was referencing as like the testamentary trust. So if you have an ongoing trust for kids or for grandkids, and that's the ongoing trust, that's going to have ongoing fees. Just your what's called a revocable trust or a living trust during your lifetime, if you're your own trustee, you're really not going to have those expenses during your lifetime unless you charge yourself a trustee fee. And most of the time you don't. So that's what some of those get at. There's different kinds of trusts, and some of these apply to some trusts, but not the others.
Yeah, thanks, Jana. Okay, let's keep going here. Now we're going to get into some of the other legal documents. We already talked about that. The next one is power of attorney, right? This is a legal document that basically allows someone else to step into your shoes and legally act as you. They can sign your name. They can write checks. They can sign legal documents on your behalf. So basically someone's stepping into your shoes. And one of the great questions is, who do I trust to do that for me, right? It's quite a power, so choose wisely. This is an important tool to get into place before you actually need it. And the reason I say that is because once you're incapacitated, you have no legal capacity to name someone as a power of attorney for you. Once you have mental decline, you no longer have the legal capacity to sign a legal document on your behalf. So get it into place before you think you're going to need it. And often it happens when we work with 50 and 60-year-old clients. Their parents are in their 80s and maybe even beyond. And we're encouraging them, hey, get something in place so when your parents need you to step in and help them with bills and getting stuff handled, that it's already in place, okay? So powers of attorney can be durable. They can be temporary, durable meaning permanent, or they can be temporary. They can be medical power of attorney or a financial or general power of attorney. So there's kind of two different areas there, and we'll get into the medical one here in a little bit. Okay. Keep going. Last one. Okay, so next one. A living will and an advanced healthcare directive. Okay. Help me, Jana. Is this the same thing?
So this is another time where this varies state to state. So when we have clients that come and say, I want X, I always ask the follow-up question, what is it that we're wanting to do? Some people call a living will, they mean a revocable trust. In my world, that's totally separate things. So we really want to get at what is it that we're trying to accomplish here? In Iowa, it's typically referred to as a financial power of attorney or a medical power of attorney. So they both serve as the same thing. Advanced healthcare directive can mean a variety of things. It can mean who you're naming, which is what I refer to as a power of attorney. It can also mean certain directions that you're saying, I want this type of care and I do not want this type of care. So I would say advanced healthcare directive is kind of a bigger umbrella that can mean multiple things.
It can. And so things like do not resuscitate order, because the medical community will do everything in their power to resuscitate you under any circumstance and keep you alive, which a lot of people say, look, if I have a terminal illness with zero chance of recovery, and machines are keeping me alive, please, right? Pull the plug. Don't allow me to linger on for years and years under that circumstance. So again, these are legal documents that give someone either instruction when you can't, or give someone power to make decisions for you. All right, keep going. One more. Now, this is a major point that trips a lot of people up in the whole estate planning discussion, is assets that have a beneficiary designation on them. And these assets are retirement accounts, 401ks, IRAs, 403bs, pension plans have beneficiary designations, life insurance, annuities, all those assets. And actually, for most people, that's the majority of their net worth is tied up in those assets. They pass via beneficiary designation. And that's important because it passes directly to who's listed. regardless of what the will says and outside of the probate process. A lot of people don't understand that caveat. Doesn't matter what your will says, because whoever you have listed is exactly who it's going to.
And I just want to hit on that again, the importance of that, particularly if there's like changes in life circumstances. And so we see this like the case of a divorce. Maybe you, while you were married, is when you got this life insurance policy, and you didn't change that when you got divorced, but you changed your will. Well, your will doesn't control the life insurance. So even if you think you know what your beneficiary designations are, I will remind you every time we talk, now is a great time to go double check them.
Yep.
Also, sometimes companies lose the beneficiary designation. If your account got sold from one account to another, it's just always a good time to check and confirm, because that operates completely separate from your will and trust.
So the common story I tell is a gentleman, this is from a court case. The gentleman out on the East Coast graduated high school, married his high school sweetheart the next weekend. The weekend after that, went down to the local manufacturing plant, got a job. What did he do? His first day, he signed up for his 401k and put his wife's name on the line. 40 years went by. He eventually climbed up to the president and CEO role, right? Very successful. In the meantime, he had divorced his first wife, married a second wife, had a family with a second wife, was married to his second wife for 35 years, and retired at 65 and promptly passed away. They pulled his 401k out, which happened to be 7 figures, and looked on the beneficiary line, and who do you think was there? The first wife was there. And of course, there was a lawsuit filed, and the second wife said, wait, that's mine. I was married to him for 35 years. We had our kids together. That's mine. And the court said, nope, who's ever listed gets it. So that's why it's so important to check on these things. Who's ever's on there, write your question down. We'll get to it. Who's ever's on there is getting that, period. Okay. So advantages. It's effective. You can list multiple people. You can list multiple entities. A lot of people use these to give charitably, right? Upon my death, I want so much to go to a school or my church or this organization. Cost and time. So remember, assets pass directly to these, whoever you have listed, outside of the probate process. Failure to maintain can cause transfers to unwanted persons. So awesome. Now, a couple more things about beneficiaries. Primary versus contingent. Okay, you have an option. Primary is who you want the money to go to first. So for most people, it's your spouse, right? If you don't have a spouse, you can list your kids. So as an example, let's say I wanted to list my 4 kids as primary beneficiaries. And then if none of those kids are around when I pass away, then it would drop down to my contingent beneficiaries. But if there's even one primary beneficiary left, that's where the money's going. Okay, so primary, contingent. The second thing is prorate versus per stirpes. And you get to designate this on each beneficiary. So prorate is just like we would expect it to. If I have 4 kids and I list each as 25%, and one of them passes away before I do, actually, my retirement account will get sent to the remaining 3 kids. So each will end up getting 33%. That's prorate. Let's fast forward a couple of years where all my children have children of their own. I would list each as per stirpes, which is Latin for per root or per lineage. So if I had 4 kids with each children of their own and listed them as 25% beneficiaries, and if one of my children was born by the time I died, but they had children of their own, that child's portion would go to their kids. It would go down the lineage. Okay. So a couple different things: primary versus contingent, prorate versus per stirpes. Did I get that right, Jana?
Yeah. And I will say there's a lot of beneficiary forms where you don't necessarily check the box for one or the other. That just means that the company has already selected it for you. And that's always important to know too. So we get that question a lot. Or we see it on the back end. Well, no, that's not what we intended. We intended it to go this way. But that form, if you didn't check the box, it has a default, and that's what's going to control.
All right. wills in the probate process. So it's estate administration. Again, we said the original will has to be submitted to the court. The court will read the will, and in the will, you get to state who your choice for executor will be. The court then asks that person, typically, do you agree to be executor? And they can say yes, or they can say no. Ultimately, the court gets to decide who the executor is, but your wishes will be taken into consideration, and that's what we want. Again, we talked about probate lasting from 6 months to a few years, and there are some exceptions that we'll get to, but the executor is going to go through the process of liquidating your property in an orderly manner, notifying the community that there's been a death and an estate established. So if people have claims against you, right, debt, then they can make a claim against the estate, pay the debts, and then make the distributions based on the will. So that is 6 months worth of work kind of scrunched down into 30 seconds, but that's generally the process. The executor is executing your will under the supervision of the court, and that's the probate process. Can probate be avoided? Generally, yes, it can be avoided. Is there a next slide? You can do advanced planning to avoid probate. Basically, rid yourself of assets that pass through probate. There's also a small estate exemption for people that maybe just own a car and a bank account, right? Something like that. That can avoid the estate or the probate process. Or you structure it so all your property passes outside of the probate. Anything else?
I have a lot of thoughts. Do you want them all now?
Well, the trust too, if everything's in a trust passes outside of probate. But let's get to that in the question, because there's going to be a lot of discussion about wills versus trusts. Okay. Keep going. So again, the estate, you got non-probate property, which is beneficiary designations, trust, and then you got probate property, which typically is real estate, things like that. So keep going. Okay, what happens if you die without a will? Each state has laws, because remember at the beginning, only 35% of people have wills. So 65% of people are passing away without wills and subject to the laws in their state. In Iowa, I actually looked these up. In Iowa, if you die with a spouse and no child, spouse gets 100%. If you die with a child but no spouse, child gets 100%. If you have a spouse with that spouse, the spouse gets 100%. If you have a different spouse that you don't have any children with, and children from an ex-spouse, the current spouse gets 50% of your real estate, and the kids get everything else. If you have no kids and no spouse, your parents get the money. If you have no parents, split among your siblings. Okay, that's all fine and dandy, but I bet each one of you have a situation where you don't really want it to go exactly like that. That's why you do estate planning, to put your wishes and to have a little bit of control out there. Did I get that right? Sound right?
Yes. I was going to say, if you're as confused as me and trying to follow if this, then that, that's the reason you do a will. Because there are so many, we're asking all the personal questions at that point of, okay, what kids did he have? Who are the parents of those kids? Are they the same as the spouse? And that's the reason why, is we're trying to follow that family tree and see which bucket you fall into.
All right, let's keep going here. We're getting close. One more. Death and transfer taxes. There are several types of tax on transfer property. At least in Iowa, I know there's no tax if you transfer property to people of your immediate family. However, there is a tax, at least currently, to transfer property to non-immediate family members. And that is a tax that the estate has to pay and file a tax return on. Okay. Anything changed in that?
No, so that's what, in this diagram, the very bottom line, that's in Iowa called an inheritance tax. So some states have state estate tax. Iowa does not have state estate tax. Iowa has an inheritance tax that is in the process of getting repealed. So it's essentially getting reduced 20% every year. I think it finally goes away in 2025 or 2026. But even without Iowa having an estate tax, the federal estate tax, which is the second line here, that's still going to apply in Iowa and in all other states.
So on the federal level, there's actually a federal estate tax exemption amount. This is a little old, this is sure, but it's 12.06 million. So the first 12.06 million for each person when they pass away is not subject to federal estate tax. Above that, the tax is 40%. So it's pretty steep. Okay. Again, that's per person. So for a couple, that's 24 million. Another thing I want to talk about quick is the federal gift tax, the annual exemption. And it's currently $16,000 in 2022, which means you can give $16,000 worth of cash or property to anybody you want and as many people as you want and make zero income tax or gift tax filings. However, if for any one person you give more than $16,000 in cash or property per year, you need to file a federal gift tax return and document that. Okay. Interesting. Now, it's an estate planning tool because some people say, how do we get money out of our estate? How do we get it to the next generation before I pass away? That's a great tool if done over a long period of time. Okay. Last one. Will versus trust. And I know we're going to spend some time talking about this and it'll come up questions and answers. Opinion is it boils down to probate versus non-probate. Now, the knock that I often hear on probate is it's costly. Probate is a public process. So whatever you file with the court is available to be seen by the public if requested. And the process that I've gone through with my mother, it's helping settle her estate. It was a fine process. I didn't mind going through the probate process. I didn't mind being executor. I added up at the end the total cost, and it ended up being about 0.5% of the estate. That's how much we paid in legal fees and court costs to settle the estate. So I thought that was very reasonable. And again, this is public record, but the attorney that I worked with settling my mom's estate said, hey, I've been practicing for 50 years and I've only ever had one of my wills looked up for public record. So it's possible, but it just, in her experience, at least, it didn't happen a lot. So I'm a big fan of having a will. Of course, I don't have any of those special circumstances going on in my life either. That may come later on and I may change my mind, but that's where I am right now at my stage of life. Will versus trust.
Yeah, so I describe it as the probate process has a purpose. And for some people, it's a very important process. One of them is you have the oversight of the court. To some people, that's a downside. It depends on your situation. If you have family issues or somebody that's potentially going to challenge it, you might want the oversight of the court. Because the truth is, if you go the trust process and try to avoid probate, if somebody wants to file a lawsuit and say that somebody's doing something wrong, you're still going to end up back in court. So it might not be the full administration, but you might end up back in there in another way. And with the probate process, it is a very clear, here's how we do it. Everything gets filed with the court. We have a judge's oversight. They're getting orders along the way. And so we have that finality. And so particularly in families or situations where there might be a dispute, probate gives us some finality that we just don't feel in the trust process. It also gives beneficiaries their day in court. If they want to go and say something to the judge and get their feelings hurt, whether or not those are valid. Whether or not they matter, they get their day in court. I've seen that. I've gone to those hearings, and the beneficiaries just wanted to be heard. So probate certainly has its purpose. Trusts certainly have their purpose. I know there's some advisors that are, 100% in one camp. Everybody needs this. Everybody needs that. I fall in it depends on your circumstances. You had a fine time with your mom's estate. It wasn't that bad as how I describe it. Nobody wants to deal with the probate process or the trust administration process. You're dealing with the death of a family member. Nobody wants to deal with it. So I'm not going to say any of them are good. I describe them as not that bad.
Okay, we're gonna open it up to questions now, and I want this is for our online folks here. Do we have a question? Do we have one back here?
A question on real estate, which cannot be a beneficiary designated asset. I don't like that, but anyway, if it is, okay, an example that me and my wife, we own 2 properties. One of them is both of our names and one of them is strictly in her name. Is there an advantage to doing it one way or the other? Because she's suggesting one of them should be in my name and one of them in her name.
Good question. What do you think?
So do you want both of them go to the same place ultimately? Like, we're not trying to differentiate. They're both going to go to, or are you?
Well, I would say my wife doesn't want to go to the nursing home.
Okay. That's a whole nother conversation, whole nother topic.
The comment was they don't want it to go to the nursing home.
Yep. So we're going to set aside the nursing home piece. If a married couple wants all of their property to go to each other and then to the kids, jointly titled property is typically going to allow you to avoid probate upon the first spouse's death because it was jointly titled. So it's back to that slide with the beneficiary designations. If it's a married couple that they own everything joint, they have each other as beneficiary designations. Typically, you don't have to do much on the first spouse's death. So if that's the case, then it would matter to have both of those joint. If you each have a piece of property in your own individual name, then you're going to have to do probate upon each spouse's death because that person owned real estate.
And it would not go well unless your will says everything goes to my wife if she's still alive. If your will says everything goes to the kids, then the house in that person's name goes directly to the kids. So you can line it up however you want.
And one question that Guy and I had talked about before, and we get a lot, is what about putting my kid's name on the real estate? Because what he just noted is Iowa does not allow you to put a beneficiary designation on real estate. Some other states do. They call it a transfer on death designation. Iowa has tried to do that multiple times. It has never passed. So it is not allowed in Iowa. But if you put your kid's name on it, in theory, so if my children were adults and I jointly owned a piece of property with my adult child, upon my death, it would automatically become theirs. Seems great, right? The issues are, what if that child gets divorced? What if that child gets sued? All of their creditors can come after that property because they're listed as a joint owner. And so it doesn't work to say, well, they don't really own it for that purpose, but they do really own it when it comes time for my death and automatic transfer. So that's the issue there on putting a kid on it. In addition to some income tax issues, you potentially lose the homestead credit for property taxes, those types of things. But
Other questions here?
How difficult is it to be an executor if you're like you have a person out of state who's coming to Iowa to, do the probate for you?
So Iowa prefers to have an in-state resident as the executor. The reason for that preference is because if the executor runs off with all the money, the courts in Iowa have an easier time going after an executor who's in Iowa than if it's out of state. So that's a preference. It's not a requirement. If all your kids, all your family members, all of your close friends, you want to name somebody out of state, it's possible. How difficult is it? Depends on the situation. A lot of things now can get done electronically, which is great, makes it a lot easier. You know, if there's a farm here to manage, they might need to be here. If it's investment accounts, can probably all be done remotely. Like I said, most things can be filed and signed electronically. I did have one instance, this was kind of at the height of COVID and travel restrictions, that the child who was named as executor was actually out of the country. And we did run into issues there because she couldn't get places to open accounts and she could not fly back to the United States. That is rare. Typically that would have been okay. She would have had to make a couple trips, do a couple things in person. Logistically, it might be easier if the person's here, but it's not a requirement.
Other questions here, Caleb? Do we have any coming in?
Just a quick one clarification. So if you put in your will that my assets are split to my wife first, but then after that, if my wife passes away, that it's given to my children, you say that my assets are split. So I have to be, we have 5 children between the 2 of us. Does that include the real estate? Can real estate be put into the will and how it's going to be split up?
No, so you don't have to say it specifically. The will is going to govern everything that doesn't have a beneficiary designation. So in your case, if I'm understanding the question correctly, if it's, let's say it's jointly titled between the 2 of you, upon your death, it automatically goes to your wife. Upon wife's death, then it's going to be controlled by wife's will because she was the only person living that owned the property. And if that says to all 5 kids, then that's going to govern that real estate and anything else that was that didn't have a beneficiary designation.
If you have lost your original will courts accept a copy that was filed with your county recorder?
Sometimes, yes. I have had it occasionally where we can't find the original will. The easiest circumstance, easiest example, I should say, is let's say an individual died in a house fire and the will was in the house. Okay, we know that we can't find the original will. We can petition the court to admit the lost will, explain the circumstances. Typically, it's going to require an affidavit by somebody that says, here's where I thought the will was, and ask that it be admitted. There was a recent court case in Iowa about a lost will that it was not that clear of a circumstance, and eventually the lost will got thrown out. That they couldn't find the original, and the court determined they did not overcome the burden that this person might have just destroyed that will. As you can imagine, the beneficiaries were going to be different, whether there was or wasn't a will. That's also going to come into play.
Do all life insurance annuities and retirement accounts allow the naming of a beneficiary with a per stirpes designation?
They should. If it doesn't fit in their exact box, so they always have a form. Sometimes it's paper, sometimes it's online now. Back when it was always paper, if it didn't fit in their box, you would be able to say see attached and could put your own designation. The other, if they had 3 spots for a contingent beneficiary and you had 4 kids you needed listed, you can do an attachment and specify that. Anytime you go outside their form document, you want to be really careful that it's clear. And so that everybody knows what you want. But yes, you should be able to always specify per stirpes.
I do have a question here. What do you think about do-it-yourself wills?
Yeah, so he might have cut out. The question was about legalzoom.com, do-it-yourself wills, those kinds of things. They can work. They might not work. And unfortunately, you won't know until you're dead. So that's the truth of the matter. I've seen them and they worked out just fine. I also worked on one that I can't remember the exact family situation, but it was a second marriage. He wanted everything to go to his stepchildren, so his wife's children. Wife died first. That's what he put in his will. He had everything going to these 2 stepchildren. Wife had left everything to him. He didn't sign the will. He did it on legalzoom.com. He had 2 witnesses sign it, but he never signed it. And that's part of the process. The document was fine, but it wasn't executed correctly. He thought it was. And it wasn't until after his death that now we're fighting over this. And these two daughters, they were adults at the time, everything from their mom was going to go to their stepdad's brother because he was the closest family member. So that's the hard part. It's like an insurance policy. Getting it done correctly, you typically only have to do it once unless there's life changes, but getting it done correctly the first time is going to be your best bet to know that it's in place. Like I said, it's not the actual document that's the problem when you go through the online process or, kind of the form documents. It's whether or not it's been executed correctly and whether another person understands what that says. Does it really legally say what you think it says?
Okay, question over here.
Jana, what can a person who is concerned that a family member or another individual is going to cause trouble with in terms of contesting a will, giving the executor some trouble that they have to deal with? What types of steps are available in the state of Iowa to kind of preempt that, or at least set up the executor to deal with it?
I'll just mention a comment here. The probate process, because it's the supervision of a court, the executor has to do everything, right? Go out and get property appraised, make that appraisal available to all the beneficiaries. You see the money moving, right? A sale over here, a deposit into the account, make that transaction available for checking on.
Yes. So, and that's one of the reasons when I say the probate has a purpose, that's one of the purposes. But what can you do ahead of time? If you think somebody's going to cause an issue, there's a couple different options. Sometimes that's a great case to have a third party, an independent third party, be your executor. So let's say maybe there's kids that don't get along. Then do you really want a kid who's perfectly capable of doing it, but that a sibling or a step sibling is going to cause issues? Do you want them in the middle, or do we hire a third party like a bank who's truly independent and not swayed by family members? That might be a good situation for them. You're less likely to argue with the bank and say you're not being fair. Well, the bank doesn't have a dog in the fight. The other family members do. So that's an option. Iowa and a lot of states allow, the legal word for it is an interim clause. You can put a clause in your will that says if someone contests the will, they get nothing. There's a couple exceptions to that. If they had a good faith reason to bring the action, then that doesn't apply. So if I go to my grandmother and convince her to leave everything to me and not to the other grandkids, and then somebody comes and challenges that, and I really did unduly influence my grandmother, then that clause is not of effect because they had a good reason to challenge it. The other important piece of that is if, for example, if you're writing a kid out, they have nothing to lose. So of course they're going to challenge it. So that doesn't help that situation. If it's, I want to leave things to my 3 kids and not this 4th kid, but I'm going to include that clause that if they challenge it, they get nothing. Well, they don't have anything to lose. So there's certain ways that you can plan and kind of do your best. I will say having some sort of third party involved is typically the best option because it just takes the family piece of it out. They might still fight about things, but you can't say you're being unfair. You're favoring this person over that person. Typically a third party is not doing that.
Well, so you can name a third party as an executor. In fact, in your will, you can name your list of first. And the other thing is you can do that ahead of time. Sorry, I lost my train of thought. Okay. Other questions? Okay.
So another one here, somebody owns, they inherited perhaps real estate that lies outside of their state of residence. So now do we have multiple probates going on?
That's a great question. I wish I could say that I told him to ask that, but I didn't. Yes, if you own property outside the state of Iowa and you have a standard will, you will be opening a probate in Iowa and you will be opening a probate in the other state. So let's say it's condo at the Lake of the Ozarks in Missouri. You're opening an Iowa probate and a Missouri probate. That's a good reason to use a revocable trust. Again, it can be done. It's not impossible. We do it. Sometimes that's what makes sense. But if you own property in multiple states, that might be a good reason to do a revocable trust, because the trust, since it doesn't go through the court systems, it can reach property in any state. You're not restricted by the state boundaries. But a court in Iowa, if you're going through the probate process, the court in Iowa can only deal with Iowa assets. It can't deal with the real estate in Missouri.
Another thing, I grasped my idea that slipped away. One of our major points is to be talking to your children about what your plans are. You can nip a lot of this stuff in the bud by setting expectations. Hey, me and your mom have done our estate planning, and here's how it looks. Here's how we have things planned. Here was our thinking behind it. And we want you to, or you kids, to honor us and get along after we're gone, right? That's the main point of estate planning, is to let the next generation know what you're thinking about and what you have in place. Other questions?
Just one more comment. So most of what was talked about today is revolves around transferring of assets, excuse me, after we've died. But and you might say, well, geez, you know, a will sounds just fine for me and a trust not so much. But there are other considerations in terms of you know, trust, to consider trust for things that have nothing to do with you dying someday. Janet talked about one before: asset protection, creditor protection, liability, those kind of things. And so everything you've heard here today really is more around what happens after I've died.
What are some in your?
Well, you know, we've all heard about Medicaid planning and, you know, look back rule. That's one example. You know, maybe your business, maybe you're in business, maybe your business is in trouble. Maybe you've got a lot of debt. Maybe you've got potential for lawsuits, those kind of things. So asset protection, those types of things as well.
Good. How are we doing on time? Okay, any other questions?
My question is, I have 3 children. I've divided the estate 3 ways. None of the children get along. I've got one that's saying she's going to contest the will. Can she contest the will if it's in a revocable trust?
She can. So it's not called contesting the will, but yes. And when we say contest the will or challenge the trust, what are we really saying? Because we get this a lot. Beneficiaries say, I'm going to challenge it. My question would be, and I'm not saying you know the answer to this, if they're getting 1/3, what is it that she wants? She thinks she deserves more, you know, so people can challenge it. That doesn't mean it's a valid challenge or that she's going to be successful. What are the grounds that we typically see for a will to be set aside? That you didn't have capacity when you did it, or you were unduly influenced. So, you know, we see that occasionally when, you know, an extreme example is dad leaves the farm to his longtime tenant and writes everything out for his kids. You know, did the tenant take him to the attorney's office and say, hey, I've been a longtime farm tenant and you've really appreciated it? You know, that might get challenged for undue influence, that he unduly influenced that individual and it wasn't really dad's wishes. When it's an equal distribution, people still challenge it, but I think that's a harder threshold of what is it that you thought it should be. So we hear it a lot of, I'm going to challenge mom and dad's will. Great. What is it that you're going to challenge? So I think that would be my question is what do we think they're going to do? We can't stop anybody from filing a lawsuit in the estate world or anything else. I can file a lawsuit because I don't like guy's suit jacket. That doesn't mean it's a valid lawsuit. So the same can apply for an estate. And we see that occasionally. We call them frivolous. And that's a good reason for the probate process. They can file their challenge. It goes in front of the court and the judge can say, I see what you filed and I understand, you know, I see what you're trying to do, but I determine this is a valid will. If they did the trust, they can still challenge it. And it's probably going to end up back in court to do that challenge. And hopefully it's still going to come to the same outcome of the judge is going to say, I see that you filed this. I disagree. And I think this is a valid trust.
Great. Time for the last question here.
Thank you. I was just curious, are there specific trust and will attorneys and is there a ballpark figure about how they charge for their service?
It's kind of a hard question. So certainly some people will acknowledge that they don't do wills or trusts. Other people's will say that they do. Throughout the state, even throughout the Des Moines Metro, you certainly have some attorneys that specialize and only do that. You have some what we would call more general practitioners that do a variety of things. There's no one size fits all. So the question, if you're looking for an attorney or if you already know somebody, would be, do you do estate planning? Can you prepare wills and trusts for me? And then you have to decide your level of comfort of, is that person appropriate? In terms of the ballpark, that's hard. That's going to be a wide range based on experience and truly based on what your needs are. We get that question a lot of, hey, I wanted Jana to do my estate planning. How much is it going to cost? At a minimum, I have questions back. Are you married? Do you have minor children? And so those types of things are all going to play into it. It's a fair question if you're going to call and, consider speaking with someone though.
All right, thank you. That concludes today. I want to honor your time. Feel free to stick around, have conversations, and we want to thank you for coming to this and being our clients and trusting us with all this stuff. Please pass on the word. We are open for business and we love to have your referrals. Thank you for your time today and hope you got something from it. Stick around.